and you can see me, and before the other people will join it, and let me give the distinction between these two words are concerned, and that is kind and types. Sometimes we'll say how many kinds of statutes are there, how many types of statutes are there, and what is the classification of statutes. So though you are using in the synonym way, but there is a slight difference would be there that we will see between the kind and types is concerned. The kind is a group with a similar characteristics. Example will say today's vehicles, that is motor automobiles, cars, etc. There are used two kinds of fuel, that is petrol and diesel. But in a slight, we can say use the word two kinds, fuel and petrol and diesel. But in other words also we may also say whether it is a petrol version or a diesel version. But type means a particular type of people think that share similar characteristics and form a similar division of a larger set. So example here I cited is, it was so dark I did not notice what type of car it was. So that was an example which I cited here. So if you see these two examples, you could have an idea that if you see the first example where I cited, uh, you can see the petrol and diesel. So petrol, fuel means petrol and diesel have one common thing. They are fuels. But because of this shared character, we use kind for them. But in the next example, we try to figure out a particular model of a car that has same feature of the same model the other, and that we have seen in the next example. So if you cite the another example in the usage is concerned, we can say she is not my type. Here I use the word type. That means I am attracted to a different kind of a girl. That the meaning. She is not your kind. That means she is a fundamentally different sort of a person. So here I am just giving the type and kind differences so that I can give the chance to the others to participate. So I could see, I did not see the other people. I could see only the 6 members have now joined. I think they are slowly maybe joining it. But meanwhile, I will continue. Yes, I am hearing their beep sound now. So one after another is joining now. So that is yes. Coming to the second screen, which I want to make it out to show the strict construction is concerned. When you say the strict construction, so that we will see it. So now time is 11:33. Still, I will give the 2 minutes time to join it. But meanwhile, I will give the something regarding the penal statutes are concerned. So when you say the penal statutes, we can also say the criminal statutes. Penal statutes, naturally, there are two things would be there. What is an offense and what would be the punishment? So if you wants to convict or make an accusation to any person, first we should see whether he will come under the framework of the offense or not. Means all the ingredients of the offense are fulfilled over there. Then we can say that he has committed an offense. And when we come to the punishment also there, the punishment should also be strictly construed. Means the punishment which are giving should be as per the law which is time being in force. So that is the construction we have to make it out. Suppose an offense is committed earlier and judgment also given and the punishment also given and everything is done. At that instance, he will be covered as per the old law is concerned. But meanwhile, a judgment is not given over there. Still, the trial is going on, and a new law has emerged over there. At the time, naturally, a lenient view of the judgment should be followed. That means, if the offense punishment is less, in the old law and more in the new law, naturally we will follow the old law. But offense is no more offense according to the new law, then the person wants to tap the new law provisions. So the court will construe it at that instance. Yes, when the two views are given, constructions are given, one is hard, another is lenient, then court will presume that let me give the chance to the accused, the lenient one. So that is the construction the court will make it out in certain cases. Now we will see the cases and we will also see and how it we will deal in this class. Yes, participants are joining slowly and slowly. So I could also saw the chart and chart is there. Yes, Srikanth was there. Yes, saying good morning. Yes, good morning to everybody. And the participant in a slow motion they are coming. Okay. So now the time is 11:36. So I will continue the class and come to the class point is concerned. Yes, and it is a strict construction of penal statutes, or we can say criminal statutes also. So in this class, we will see that some of the introduction and Maxwell, that is one of the renowned justice, what he said, and another renowned justice, Lord Esser, what he says regarding the how the construction should be there, and generally we will follow these their principles, and we also see the some judicial decisions to see that how the construction for the penal statutes are decided and in this online class. So now, when you go to the yes, participants are slowly joining over there, then I could see the chat. The chat also saying yes, Sachinana Usharani was there on the line. And then, and I will go to the main point. In a penal law, there are appears to be a reasonable dubiety or ambiguity. The ambiguity is there, it shall be decided in favor of the person who would be liable to the penalization. If a penal provisions fairly be to construed as to avoid the punishment. So the fair meaning should be taken, and the meaning is very much fair. That meaning should not be stretched and to different extent and make the increase the punishment or make the punishment more. It must be so interpreted if there can be two reasonable interpretations of penal provisions. I repeat, if there can be two reasonable interpretation of the penal provision, the more lenient should be made applicable. Just now we discussed. Let we'll give the benefit to the accused. The more lenient should be applicable over there because the law is based on let the 99 innocent will be released, but no, let the 99 what a convicted would be released, uh, but one innocent should not be convicted. So that was the regarding the basis of these penal statutes. Let 99 will be allowed, but one innocent could not be punished. That is the whole idea. Punishment can be meted to one only if the plain words extension of the meaning of the word is allowable. It means a penalty cannot be imposed on the basis that the object of the statute so desired. So when they are constructing the statutes, parliamentarian should have to make it very strict sense, and even judiciary also should not stretch it the meaning, and moreover when the hard punishment would be there and the lenient punishment would be there, then accused will be given a choice for the lenient punishment. According to Maxwell, the rule of strict construction of penal statute manifested in the four ways. So he pointed out the four ways how the construction should be there. Let me see the participants. Yes, participants are there. And I think that you are listening to my voice clearly, isn't it? Then number one is concerned what the Maxwell says. The first point regarding the construction of the penal statutes are concerned. The express language is necessary for creation of criminal offense. The language should be very much clear. There should not be any ambiguity. Therefore, no act is to be deemed criminal unless it is clearly made so by words of the statute concerned. But it is not necessary that a particular penalty be specified in order that an act or omission may constitute an offense. So, what I want to say in the first place, the language should be very much express, and criminal act we should not take it unless all the words of the statute concerned will be fulfilled. That is the first section, first point says regarding according to Maxwell. The second point, Maxwell said, the words setting out the elements of an offense are to be strictly construed, and if there is any reasonable doubt or ambiguity, it will be resolved in favor of the person charged. So naturally, in the criminal proceedings are concerned, beyond a reasonable doubt. If a doubt would be there, naturally it should be given it should be in the favor of the accused only. Like the if the doubt would be there in the cricket play regarding the whether the batsman is out or not, then naturally a doubt what clearance generally would be in the favor of the batsman. It will be given in the same manner. Here also, if any doubt would be there, then the advantage of the doubt will be given to the person charged. That is the second one. So, a reasonable interpretation which will avoid the penalty must be adopted. If there are two reasonable constructions, the court may give the more lenient one. Yes, this we discussed earlier. The court must always see that the person to be penalized comes fairly and squarely within the plain words of the enactment. That is the second point, according to the Maxwell, in construction of the penal statutes are concerned. Then the third is punishment can be imposed only if the circumstances of the case fall clearly within the words of enactment. So regarding a punishment, it can be imposed only at the time only if the circumstances of the case fall clearly within the words of enactment. If the words of the enactment clearly it comes over there, then only this punishment will be imposed. Otherwise, it cannot be imposed. Then comes the fourth one. Similarly, statutes dealing with the jurisdiction procedures are, if they are related to the infliction of penalties, strictly construed. Regarding the statutes with the jurisdiction and procedures are concerned, yes, it should be strictly construed. The general rule is that all penal statute must be strictly construed. That is the general rule. What here it says. So people are joining, I believe, and let me go further. Let me see if anybody is waiting. Nobody. Participants are there. Yes, they are coming one after another. And so let me continue it. According to the Lord Escher, that MR, Lord Escher, he said, like we have Lord Atkin, Blackburn, Lord Dennings. So here Lord Escher also, one of the renowned Lord of English court. The settled rule of construction of penal section is that if there is a reasonable interpretation which will avoid the penalty in any particular case, we must adapt that construction. If there are two reasonable constructions, we must give the more lenient one. Again, Escher also given the same, which one is the harder one, another is the lenient one. So better the choice will be given to the accused, and the lenient view should be taken. So that the court will decide in that way. So now we will see what are the judicial decisions will say regarding the strict construction of the penal statutes are concerned. So in case of M.U. Joshi versus M.V. Shimpi, this is the case where the appellant was convicted under the section 16 of the Prevention of Food Adulteration Act 1954. So here the appellant was convicted under the section 16 of the Prevention of Food Adulteration Act 1954. For what? For selling adulterated butter. So he was selling the adulterated butter. That's why he was convicted under Section 16 of the Prevention of Food Adulteration Act 1954. And he, means here appellant, contended that it was not butter within the meaning of the rules made under the Act. So he say the definition will not come butter under Section 16 of Prevention of Food Adulteration Act, because his contention was that that butter means butter made from milk, whereas he had sold butter made from curd. So he prepared the butter from the curd and he sold in that way. But the Act says butter made from the milk. Then only it will attract the Section 16. That was the contention of the appellant. Further, the Act being a penal statute, the word butter had to be strictly construed in favor of the accused, whether it is made from milk or made from curd. Butter is a butter. The Supreme Court, while rejecting the contention, held that strict construction means that the conduct of the accused of his conviction must fall within the plain words of the penal statute without straining their natural meaning. Butter means butter, whether it is made with the curd or made with the milk. And as you know that we can make the butter with the milk, and we can also make the butter with the curd, and because every Indian knows it. So here the contention was whether it is made with the milk or made with the curd doesn't make any difference, because you have to take the word butter means butter. How it is made, it is not the point, and we cannot give such a thing. So butter means butter. So there is no ambiguity here, and that's why. And he did not get the what is it? Section 16 would be applicable to the appellant, and here strict construction is made, so he will be convicted for the offense here. So meaning butter is butter. The same thing which I made it here. In the present case, the word butter is clear and there cannot be two meanings of it. Therefore, the question of interpreting in favor of the subject does not rise. The contention of the appellant that butter made from curd is not covered under the rules made under the Act does not stand, because butter is a butter, whether made from milk or made from curd. The intention of the legislature is quite clear from the language it has used, and there is no room for the doubt. And when there is no room for the doubt, naturally the plain meaning should be taken into consideration. So that is happened in the above case law. So before I could go to the case law, I would say anybody is standing there. Yes, Parvin Kumar is waiting, so I should say admit. So I admitted Parvin Kumar. Then we'll go further. If there are two reasonable constructions, the court must give the more lenient one, as we decided earlier. We said in the earlier also. It was observed in the case of Ratan Lal versus State of Punjab. This is the case. The accused, a 16 years old boy, was convicted for outraging the modesty of a girl aged 7 years after having committed house trespass. I repeat, the accused, a 16-year-old boy, was convicted for outraging the modesty of a girl aged 7 years after having committed a house trespass. So the magistrate awarded him imprisonment for 6 months and fine. After this sentence was passed, the Probationer Offenders Act 1958 came into existence. So a new act came because he was made under the old act. Probationer Offenders Act 1958 came into existence. As per the new act, based on the new act, it is clearly said, Section 6, restrictions on imprisonment of offenders under 21 years of the age. That is put it over there in Section 6. The restriction on imprisonment of offenders under 21 years of age is put under the Probation of Offenders Act 1958. And based on the age ground, the accused appealed to the additional session judge and then to the High Court in revision without claiming the benefit under the Probation Offenders Act. And after the High Court rejected his revision, and the appellant, he pleaded before the Supreme Court for benefit of Section 6, as he was below the 21 years in age, the Supreme Court by a majority held that benefit of probation could be given to him. But here in this case now, the offense was made under the old act, but meanwhile a new act has came, but the new act is giving uh, some excuse to the appellant, so he would like to tap the section 6 of the Probation of Offenders Act 1958. So they said better when the two explanations are given over there. So, which explanation is more lenient, that should be given to the accused. So here, the accused regard the leniency of the 20. He is under the 21 years age. Hence, he took the advantage and applied for the section 6 of the new act, where the lower court they dismissed. That is the additional Sessions Court and High Court, they dismissed it. They did not apply the new act, but the Supreme Court has made the construed the lenient approach, and it is given. The majority held that the benefit of the probation could be given to him, so he was given and that's why he will not be convicted and he will be acquitted as per the new act is concerned. So that was the decision which is construed over there. When the two constructions were made it over there, but which is more lenient would be given to the accused. So that the same thing happened in the above case. Let me come to the another case, that is Alamgir versus State of Bihar. The wife left her husband voluntarily, and her free will came to stay with the appellant. On the question whether the appellant was guilty of an offense under section 498 of IPC, so that was the question. It was held detention in the context of must mean keeping back a wife from her husband or any other person having the care of her on behalf of her husband with the requisite intention. So here the intention is very much clear. Even the wife came voluntarily and staying with another man, then definitely he comes under the section 498 IPC, and the appellant was held liable under section 498 of IPC here. So the plain meaning will be given over there. Even though she came voluntarily staying with the appellant, yes, that is comes under the 498 offense. The condition for the 498 is clearly applied over there, so the appellant was liable under the 498 of the offense here. So now we'll see what other case law says regarding the strict construction of the penal statutes are concerned. So, in Chinnu Bhai versus State of Bombay, several workers in a factory died in inhaling the poisonous gas when they entered into a pit in the factory premises to stop leakage of poisonous gas from the machine there. So, the inspector of factories on inspection did find beating and revising the apparatus, belts and ropes in the factory done damage in violation of the Section 4 of the Factories Act of 1948. So now the question is whether the employer violated the Section 3, that is the welfare place should have to provide it for the employees. Section 3 of the Act, which says that no person in any factory shall be permitted of the Factories Act 1948, does not impose an absolute duty on the employer to prevent entry of persons in an area where dangerous fumes are likely to exist. So the mere fact that some workers went inside the pit does not prove that they were permitted by the employer to enter. So whenever there any fumes are there, any things are there, naturally the employer will stop them to go over there and nobody would be allowed. But these employees went over there where the fumes are coming. So the prosecution must prove that the first before any defense was called for. Since the prosecution fails in its duty, the employer could not be convicted here. So what the section 3 says, the welfare place that you have to make it out, and they did it, the employer, but the employees they did not follow the instructions and then went over there. Hence, the employer is not liable because the penal provision should be strictly construed over there, and hence the employer come under the exemption and he will not be convicted. In another case law, we'll see that is Sarju Prasad versus State of Uttar Pradesh. And here the employee who was an employee in the shop was convicted under the Prevention of Food Adulteration Act 1954 for the having a sold the adulterated food. Yes, again adulterated food is concerned. Yes, a person who is selling such a thing, whether he knows it or he doesn't know whether it is adult food or not adulterated food, but the guilty mind is not considered over here. That is Section 16 of the Act, because the enactment being a penal statute had to be strictly interpreted. Section 16, which penalizes selling of adulterated food, and Section 19, which says that absence of a guilty knowledge is not a defense, were interpreted by the court. The provisions clearly state that the knowledge on the part of the seller is absolutely material for the purpose of conviction, and therefore the appellant's appeal must fail. So here the appellant could not take the defense of Section 19, which is the guilty mind, whether he is selling the adulterated food or not. As per the Section 16, he is selling it, hence he would be held liable. So here guilty mind is mens rea is not counted. But when there is the absolute liability is there, when the offense is so much grievous one, hard one, at that instance, definitely the guilty mind is there or not will be taken into consideration. So we will see in this case law here, Ranjit Udaishi versus State of Maharashtra. In this case, the appellant was convicted under Section 292 of Indian Penal Code by the High Court. For what? For selling an obscene book, the title Lady Chatterley's Lovers, which is written by the D.H. Lawrence, for the sale of which was banned by the government of India. So that book was banned by the government of India, that is Lady Chatterley's Lover. Of course, there is another book also there, we will see Lajja, which is also banned in India, and it is a Bangladeshi writer who wrote it, Tasneem. I think I name is Taslim, I think. Yeah. So some books which are banned over there and they should not be sold. That is the law which is made. So the accused contended before the Supreme Court that mens rea of the accused has always to be proved to maintain the conviction under criminal law. But he said he did not have any intention like that or a guilty mind. But the court observed, the Supreme Court rejected this argument of the seller and held that on a plain reading of Section 292, it is clear that proof of mens rea is not required for conviction. Under this section, mere selling or keeping for sale an obscene literature that has been made punishable. So the appellant is guilty on the basis of the plain reading of the enactment, and therefore his appeal must not succeed. But in the Sweetie case, it is different. Here, the mens rea is counted because it is a dangerous drug act comes over there. There is absolute liability. In case of Sweet versus Parsley, and where absolute liability is then mens rea of the statutory offence under the Dangerous Drugs Act 1965 is taken. Here, facts of the case like this: the appellant Stephanie Sweet, represented as yes, was a subtenant of the farmhouse. See, note the point. She was not the owner of the farmhouse. She was a subtenant of the farmhouse, and where cannabis resin was found, which is a psychopatric substance. And Sweet no longer lived in the house and had let out several rooms to tenants. And she did retain a room, but only returned occasionally to collect the letters and rent. So she escaped one room. Sometimes she comes and see whether there any letters are there or not. For that purpose, she kept one room over there. The appellant was charged and convicted under the Section 5B of the Dangerous Drugs Act. That being a concern is the management of premises used for the purpose of smoking cannabis. Actually, the subtenant give the tenants to the students, and the students use these narcotic drugs over there. So that was the point actually. So issue was that whether 5B 1965 Act, whether the mens rea should be needed or not, that is the question over there. So in such cases, it is clearly mentioned that the Stephen, that is Sweet, appealed against her conviction because lower court convicted her, claiming that Section 5B required the mens rea of knowledge of the prohibited purpose which the farmhouse was being used for, while S, that is Sweet, accepted the premises had been used for smoking cannabis resin, but she had no knowledge of this use. So, but she doesn't have the knowledge that the premises used for consuming the psychopatric substance. So the court held that conviction was therefore quashed as Sweet did not have any requisite mens rea for the offence of under Section 5B of the Act. So it is clear that strict construction could be made where knowledge is more important for absolute liability. The reason is Sweet conviction was quashed in the appeal. So when there is absolute liability would be there, at that instance, the court will consider whether the person is having the guilty mind or not. This will definitely be seen. And we have a different case law also here, like the same thing, like what is decided over there, that is Indrasen versus State of Punjab. So if I just give the brief of this case law is concerned, actually the apples were he is exporting or he was transferring from one place and another place, but he doesn't have the knowledge that the apples container is also having the some narcotic drugs like opium. So, according to Section 9A of OPM Act, he was convicted from the lower court and high court. But in appeal, special leave petition he made in the Supreme Court for the effect of it, and his contention that he doesn't have a knowledge of opium that is of him or opium were there in the containers because he is only transporting or conveying the only the apples. So the appellant contended that unless otherwise provided, it must be presumed that the legislature will not make any act offense unless it is accompanied by mens rea. As there was no mens rea provided by the prosecution, appeal was allowed and the appellant was acquitted. So here mens rea is taken into consideration and the appellant was allowed here. So that is the gist of the case. One case we will see here is the state of Punjab versus Ram Singh, and there, let me see, people are there. No, people are not there waiting. Yes, in the state of Punjab versus Ram Singh, here a heavily drunken constable gunman was seen roaming in the market with service revolver while he is on duty. So a policeman fully drunken on duty and he was roaming on the road with a service revolver when he was in duty. When he was sent to the doctor for medical examination, he abused the medical officer on duty and which shows his depravity or delinquency due to his drinking habit. So here the Supreme Court held that his conduct would constitute a gravest misconduct warranting the dismissal from services. Because a person who protects the law, he should not be a breaker of the law. And hence here the policeman is broken it. So the Supreme Court taken a stringent view. So the authorities therefore were justified in imposing the penalty of dismissal. In fact, Constable should be suspended and disciplinary action would be taken against him. But his offence is such a grievous and delinquency. In this case, Constable misconduct was warranted the court for his dismissal. So he was dismissed. That interpretation strictly the court followed in this case now. So we have the other cases also, like Appa Sahib versus State of Maharashtra. That is also one case law. And we have a Tolaram case law. Let me see the Tolaram case law now. Tolaram, Rolumal and another versus State of Bombay. And here if I give the gist of the case law is concerned, before the construction of a building and he took some pagri or he took some loan or he borrowed some money from the person to whom that he is going to give the lease his apartment when he fully constructed the building. That was the total idea behind this case law. So they said taking the money from the person who is going to come as a tenant under Section 18(1) Bombay Rents Control Act, they say it is an offence. But here Section 18(1) would not cover an executor contract to grant a lease. There is only an agreement that the landlord would lease to the complainant a particular flat after the building has been fully and properly completed. So it does appear that Section 18 subsection 1 does not bring within the mischief executory agreements of this kind. Therefore, it is outside its mischief. The definition will not come. So, Supreme Court allows this appeal and set aside the conviction of the appellant uh, and ordered that they will be acquitted. Hence, appeal allowed in this case by following the plain meaning, by curbing the mischief, not stretching the meaning of parliamentarian, and remedy was allowed by following the strict construction of penal statutes. So, what I want to say is, if a person will come under the real wordings of the statutes or not, like here, section 18, subsection 1, whether the offender will come under the strict under this section or not. So if they come under the strict definition, then he will be penalized. If not, he will not come under the definition, then the definition will not be applied over here. So in this case law, which I just referred, that is the case law is, yes, the case law is Tularam Relumal case law. It is clear that it will not come under the definition, hence he will be released. In conclusion, I would like to say that after the detailed analysis of various methods interpreting a penal statute in the online class here today, and we categorize the method by concluding first, the basic rule of interpreting such law is to strictly adhere to the language of the statute, since it is the will of the legislature, and the court should restrain itself from the stretching the meaning of the words, causing unnecessary hardship to the subject. Second, it must be always kept in mind that what is the purpose of which the enactment seeks to achieve, and if the strict adherence is done, it will be able to achieve that purpose or object. The last, thirdly, whether any such interpretation, the mischief which was sought to be suppressed by the penal law, was suppressed, and if not, then it is the duty of the court to ensure that it is done. And just because of the legislature's omission, the injustice to the society should not be administered. So now, if I want to conclude it, the court will see whether the person who is an accused come under the definition of the section or not. That is, they will strictly follow it. And then number two, if the two opinions are there, if the two provisions are there, if the two interpretations are there, then a lenient interpretation should be given over there. So that is the court's approach regarding the strict construction of the penal statutes are concerned. So that we say, beyond the reasonable doubt, based on it, let the 99 what is accused will be released, but one innocent cannot be convicted. That is the idea behind it. Now I will have still 6 minutes in my hand to ask the participants. Here I found Bhulakshmi Devi Pagad. Now I admitted her. She joined late. Then I saw the chat also. The chat I closed it. Now you can ask any question. I could hear your voice. Yes, please. Yes, I could hear your voice. You can ask the questions, please. So now the doubt clearance regarding the penal statutes are concerned, and you can ask me whatever the doubt that you have regarding the penal statute, so that I clear the doubt. Please proceed. Yes, I could hear your voice. Are you hearing me? See, I'm speaking that yes, I shared this one. The interpretation of statutes are concerned. Yes, if anybody could speak and ask me the questions regarding today topic is concerned, that is strict construction of the penal statutes are concerned. Perhaps I could not hear your voice. You can chat me if you say it's like that. But I heard the voice just now. Yes, anybody can speak. Chinni Praveen Kumar, CK. If you speak, if I could not hear you, you can chat me also. You can send the SMS regarding the doubt is clear, is concerned, so that I could clear your doubt. Now still we have in your hand 5 minutes. Yes, I could hear your voice. Anybody wants to ask me anything?
Hello,
Yes, yes, I could hear your voice. Please speak.
sir. That is the case of state of Punjab and Singh,
Uh-huh.
that head constable. Constable.
Yes, constable case is concerned. Actually, what they did
Yes,
it,
sir.
they followed the very strict construction because a person who is a law maker should not be a law breaker. So the disciplinary action would be taken. Naturally, he should not be suspended. He should be dismissed because it is a model to the other people. So strictly they followed what they put it in the statutes are concerned. And a person who is on duty should not supposed to drink. And if he drunk and made a misbehavior, that is not a misconduct. That is a high degree of delinquency is there. Hence, he will be dismissed over there.
Sir, here in this case, sir, actually,
Oh,
punishment given by the disciplinary authority
yes.
has been supported by the court.
Yes, 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 yes.
Interpretation of the court here.
Yeah, the interpretation of the court is there. They said if the matter reached to the court after the disciplinary authority, the court will follow. Yes, he did it such an grievous act which is worth enough to give the
Sir,
punishment of a dismissal rather than the suspension.
he should not have.
Yeah, that is to me also there should be a stringent punishment is given to the police officer. But one should be there. He should be suspended for sometimes. But they here they dismissed him completely. That was the thing. That's why I wrote suspension is preferable rather than the dismissal.
So he was a law breaker there.
Yeah, that would actually they want know. కంచెనే చేను మేస్తే చేనుకి ఎవరు కావాలి you will say in Telugu.
The law protect the law. Sir,
Yeah,
the law protector became
a
law
law
protector became the law
protector should not be a law violator. That's the point they want.
breaker. Yes, sir.
So that's the reason they
Yes.
have dismissed it. So to an example to other person, like the person who is selling the butter. See, butter is a butter. Whether you made with the milk or you made with the curd, it doesn't make any difference. It is a when it is a adulterated butter, is a butter. That's all. How it made is not the question. So they said,
I have a doubt,
they
sir. I have a
said,
doubt, sir, here.
yes, please,
Sir,
yes, speak.
usually the butter taken from milk is known as cream, sir, actually.
Butter?
The butter manufactured from the, I mean, taken out from milk, it is
No,
known
no.
as
The two,
cream.
yeah, by two ways we can take the butter. We can take the butter from the curd. We can take the butter from milk. Suppose if you boil the milk, migad antar the cream. You can take the cream and put it and add some curd to it. Or when you are preparing for the curd also, you will get the butter over the curd. And that cream also you can take it and put it for several days by adding a little curd to it. Then you churn it. Automatically the butter will come over there. When you burn it, heat it, then ghee will be formed. That is the process of making the ghee. Is it not?
The decision of the court.
Yeah, court said, see, either you make the butter from the milk or you make the butter from the curd. It doesn't make any difference. But you are selling the adulterated butter, hence the plain meaning will be taken, and there is no exception and there is no stretching. So that was the meaning which is given over there.
Thank
Yes,
you, sir.
any other person wants to ask any other question? You can ask because still 1 minute is left for me to give the answer to your questions. And see that you have to listen the case law and you have to go through once the case law because these case laws are available in the online also. If you want to have the depth of it, you can go through the depth of it to see whether a person who committed a particular offense come under the definition of the offense or not. But the code, one should not stress the meaning of it. You should have to construct only strictly construed over there, but not without stretching the meaning of it. So that is the point. Strict construction will come. I told you, let the 99 persons will be acquitted, but one innocent cannot be convicted. That is the beyond the reasonable doubt. This construction is made. Like when the two opinions are given over there, a lenient opinion will be given to the accused because the benefit of doubt will be given to the accused. Like in the cricket case, cricket, a batsman, when doubt is there, so benefit of doubt will be given to the batsman, but not to the bowler. Is it not? Yes, any person, because now the time is 12:16 and 1 minute we crossed, encroached on your free time. And if there is no doubt, and the next class is strict construction of tax statutes. That we'll deal it in tomorrow class, and I will try to put it in YouTube also, this today online class, so that you could hear it. I think it will be nicely will be recorded over there, including the question and answers also, and who asked the question and what the answer I have given, and that is a full proof. That is a very much transparent. Uh, and let me close it. I want to say goodbye and a good day to everybody. And I stop my sharing, then I will stop
Thank you,
my
sir. Bye, sir.
meeting also.
Thank you.
Yes, thank you very much for your
Thank you.
patience.